All right, as soon as I've got the department on camera, I'll figure out who we need. Morning, Ms. Ball.
Judge, have you seen anything? Do you know why this came back from Smith County? Did they just move back or?
Yeah, that's my understanding.
Okay. I mean, I haven't been able to get a hold of Derek. I guess he's working two jobs, so his voicemail was full. I couldn't leave him a voice message.
Okay. Mr. Abbey, who are you looking for? Miss Sledge?
Yes.
Okay. We're here on a quarter of service compliance hearing today. We are conducting this through Zoom. We are live streaming, and Ms. Goodman's making a record for us this morning. All right, we'll go ahead and take announcements.
Todd Albee on behalf of the Texas Department of Family and Protective Services. Present, ready to proceed. Katrina Sledge is the FBS worker who will give us an update today.
Savannah Kincaid, I represent Miss Neal. We're present and ready.
TD Hammonds for Derek Rubin. Ready, Judge. I don't know if he's joined us or not. I wasn't able to get a hold of him.
He is not.
And like I said, he's working two jobs. He may be at work.
He's currently present. He's actually here. We're here together on Zoom. He's listening.
Okay.
Right. Ms. Neal, can your picture is very blurry.
Yes, ma'am. I'm trying to fix it. I'm not sure what's going on.
Okay.
Let me try and fix it real quick.
All right, but he is there with you, so.
Yes, ma'am.
Okay.
Stacy Zabala on behalf of the children.
Yes.
All right then. Ms. Sledge, if you want to give us an update on how things are going.
Yes, ma'am. So since they've come back, September 5th is when I made contact with them again. At the apartment, I made contact with Zelenia and the children, verifying their return to Amarillo. We had in-depth conversation prior to her coming back about the concerns of her coming back due to, as Derek hadn't really engaged in any services to address some of those concerns we had in regards to the volatile situation between the two of them. But she had completed, give me a second here. Prior to her returning back to Amarillo, Jalea completed parenting. Let's see. She completed anchor control, the psychological evaluation in parenting. She was actively participating in individual counseling, and the couples counseling. It was recommended for her to complete couples counseling, but when she left due to safety reasons and fear, and did not choose to pursue a relationship with Derek, it was said that, as long as she was doing that, then there was no need for couples counseling because they weren't pursuing a relationship. So upon her return here, that was something that was suggested that they do follow through with some type of couples counseling because of the volatile situation, and that she would continue through with individual counseling with Danny Eves out of the Tyler area because she had already had 3 sessions with him. So there was 3 of 6. The goal was possibly for her to continue with him because that report was already built. And the contact with him has kind of been short. I hadn't really been able to have a whole lot of contact with him, but he did agree to continue individual with her, but he wanted to make sure he understood the dynamics and what was needed more to help and kind of work with the situation now that she's back with Derek. Derek, he had not completed anything prior to the move, but he did just recently complete his fatherhood fire program.
It wasn't, excuse me, it wasn't recently. It took 3 months to complete this program.
Okay,
Right.
so hang on. Hold on. All right, sir, you don't just get to interrupt whenever you want. I'll get a report from her, then I will get to each one of you. Okay, so just hang on to your thought. When it's time for you to talk, you'll have your chance.
Okay. So the 24/7 dad program was a 12-week program, so it was a 3-month program, and he just completed it.
Okay, sir, I'll either mute you all until it's time for you to speak, or you'll need to be quiet. We have a court reporter. She has to take down everything that everybody says. And when you talk over people, she can't do that. So I'm not picking on you. I'm just, we're trying to get a nice clean record of what everybody says today. So just wait until you're called on. All right, Ms. Sledge, go ahead.
Okay, so he completed the 3-month 24/7 dad program. He did a great job according to the facilitators there. That program was completed last week. And so the other services that were recommended for him were individual and couples counseling, of course, the batter's intervention program, and then the parenting, which he has done. Drug screening, random drug screening was testing, was also recommended by the parents, but contact has been very minimal with both of them. Derek is working 2 jobs. Jalea just started working a job at Lone Star Dental since she returned here. Derek admitted to marijuana usage back in July. And then Jalea had a incident prior to returning to Amarillo area with marijuana, in which she was unaware that she was at a party and not aware that it had marijuana substances in it, but that was addressed there in Tyler. So there hasn't been any drug testing since she returned back here for neither one of them. The kids are doing great. Dallas is in daycare at Happy Days. He's doing great. They come every day clean. He goes every day clean. He's adjusting well. Zoe is doing great in school. She is excelling. She's opening up. She's doing well academically, coming clean every single day, and is there every single day. They did rave about how she always brings her homework. She is one of the kids that raves about her homework, and so Jalea does really well with that and assuring that that her homework is done. Education is a big thing for her. There have not been any police call-outs to the home in 2024. I did verify that. The last police call-out was the one in October, which resulted in our report in which Derek was the victim to Jalea. There hasn't been anything new since they've been back, and there hasn't been anything new since in 2024. That's where we're at with it.
22.
All right, then I've got a question, Mr. Alley. When did this case begin in Smith County?
Well, I think it began here and then we transferred it to Smith County. And I can't tell you the exact dates. Miss Sledge, do you have those dates?
Yes, so it started here
Okay.
I'm sorry.
Go ahead.
Okay, it started here in Amarillo. Let's see, the start date of this case, I'm sorry. It started here in December of 2023. And that was as a result when we initially got our report. And it was the 3rd domestic violence report without it being referred to the department. So when we finally got it in October, December, that was the final report in which Derek was the victim to Jalea.
When did we enter the first order?
The very first order was, give me a second.
The reason I'm asking this is because I think this was originally under a different cause number.
Yes, ma'am, it was.
Yeah.
It was. Yes. Give me a second. The very first one would have been legal action 9/12. No. Is that right? No, that's 9/12.
Oh, excuse me. Why would you said that it was a different cause number?
Yeah. What I need to know is how long has this been pending? And I guess the court in Smith County maybe granted an extension at one point.
That's what my understanding is, Your Honor.
We need to know when that is. Because it's
Leslie may have that
dangerously
So
like
it started, it actually transferred over in February of beginning of this year.
that's not what I'm asking. Y'all, let me get the answer to what I'm asking. When was the original order to participate entered?
12/22/23 is what I have. Order.
12/22 of 23 was the OTP.
Yes, ma'am.
All right. Do we know what date the court in Smith County granted? I assume it was a 180-day extension.
Give me just a second. Legal action. So give me a second here. On the hearing date was September 12th of 24. Let's see. That was the OTP hearing date. Yes. September 12th of 2024 is what I have in our documentation note-wise, the narrative.
May 30th is their first hearing that they had of 2024. That was the August one is their most recent hearing. So the first hearing in Smith County was in May.
when did Smith County give the 180-day extension? That's what I need to know.
Judge, it's on the May 30th order where they
Okay,
granted the extension. And the order in August where they had the next hearing had the old dismissal date in November, but I guess that was just a typo. So the dismissal date is December 15th of 2024
okay,
with the
that's-
extension that was granted back in May.
Okay,
with
so
Smith County.
that's the deadline of the 180-day extension.
Yes, ma'am.
All right. Okay, which will lead up to the penultimate question here in just a minute. All right, then. Ms. Kincaid, do you all have anything to report today?
Nothing much to report, Your Honor. Ms. Neal is doing well. It appears to me. I did have a question for Ms. Sledge. Is there anything remaining for Ms. Neal to complete?
She has not, they haven't completed individual counseling from the update I received from Counselor Eves. Haven't started re-engaging in that individual counseling, and I haven't got an update for him, so I'm not sure. And then the couples counseling is something we would like for them to do since they are choosing to remain in the relationship or, co-parenting, something of that nature. So those are the two things that we have left remaining are the individual counseling and then couples or co-parenting.
Okay. The couples counseling hasn't been ordered by the court though at this point, has it?
It was ordered initially because they were together and then, so.
Okay.
That was recommended.
Hang on, sir. I'm not going to tell you again. Go
Okay.
ahead.
Thank you, Your Honor. Would you agree with me that getting in contact with her counselor has been difficult for both you and her? Would that be
Yes.
fair to say?
Yes.
Okay. And have you had an opportunity to go to the home?
Yes.
And has Miss Neal granted you access to the children, whether it's announced or unannounced?
Yes.
Okay. Has the house appeared to be clean, safe, and appropriate for the children?
Yes,
Okay.
ma'am.
Thank you. I'll pass witness.
All right, and Mr. Hammonds?
Judge, I don't have anything to ask Mr. Rubin, but Mr. Rubin, this is your opportunity to tell the judge how you've done on your services and how you'd like to see this to proceed.
So can I speak now?
Yes, you may.
Yes.
I was recommended for a few services, but I was having trouble signing up because their classes were full. So that was why it took so long for me to complete one of my classes. I think it's the parenting class. I had to wait like 2 months to get inserted into the program. So that's why it took so long to finish the program. But me and Julia, we've been communicating. We've been working on our relationship for a while now. And when she decided to come back a couple months ago, it wasn't just out of the blue. We've been speaking on it and working on it as a couple for a while now. And we don't have any problem finishing the services that y'all recommend, but we just ask that the court take into account the fact that this has been going on. This case has been going on for almost over a year now, and there hasn't been any new incidents as far as police or the kids being put in any harmful way or anything like that. We just ask that y'all try to work with us to get this case dismissed, please. Because we don't feel that we should be having to continue to deal with child protective services. We feel that the problems that brought this case upon the court has been resolved, and we feel that we're able to prove that, and feel like we've been proving that for the past year now. So, I'll let y'all go ahead and choose what y'all decide to do with the case and what y'all order us to finish.
Well, okay. So, Ms. Zavala, I'll get your report and then we'll confront the obvious problem.
Your Honor, I got a great thorough report from Ms. Sledge. We just received contact info just the other day. Kelly started reaching out, has not heard anything back, but it was just recently. So I was going to let parents know that she will continue to call and reach out and set an appointment for me to come by, but I have not seen them since they've been back here.
Okay, so it's really important that Ms. Zavala be able to see the children. She's their attorney. Her relationship with her clients is just as important as your all's relationships with your attorneys. So be looking for contact from them. All right, so Mr. Alley, what's the department proposing to do since we are up against a dismissal date?
Judge, we would just ask that you continue it until the 15th when it would be dismissed, and that we would continue to ask the parents to work towards completing the counseling and the couples counseling. I think it's too late for a BIP program. I don't think Mr. Martin could get into a BIP and finish it, so I'm not asking for that. But the individual counseling he needs to continue to work on, and the couples counseling between the two of them, and we're talking about a month, Your Honor. We could probably get at least the 3 that Miss Neal needs to have completed.
Okay, so Ms. Kincaid or Mr. Hammonds, neither of you, your clients, are requesting that we extend the case again. Is that correct?
No, Judge.
Ms. Neal feels like she's, adequately completed the services and has been in compliance. So I don't think that she would ask for an extension at this time.
Okay.
Not at all. As far as everything is with the kids since we've moved here, they've excelled tremendously. My son, at only 2, he's writing his own name. And as I said, for Zoe, for her homework, she's already reached the all A honor roll, and she's brought back her progress report and all A's and B's. So primarily, we just want to make sure that we finish everything that needs to be done, so that we can just, continue to grow with our children and move forward with our lives.
All right, then, what I can do today and what I will do today is just continue the order to work your services. You all try to complete everything you can until the dismissal date on December 15th. And at that time, by operation of law, the case will be dismissed.
Sounds good.
Thank you, Judge.
All right, and I will just tell you, unless Ms. Neal, either you or Mr. Rubin request that the case be extended so you can complete something, that would be at the department's expense. Otherwise, it will dismiss by operation of law. Okay, I appreciate it. There won't be, I'm not going to announce a further hearing date because nobody's asking for this to be extended at this point. So that'll be it. And I wish you all the best of luck.
Thank you.
All right, thank you.
Thank you, Judge.
We are here on a review hearing. We're conducting this through Zoom. We're live streaming, and Ms. Goodman is making our record. We'll go ahead and take your announcements.
Todd Alley on behalf of the Texas Department of Family and Protective Services. I'm present, ready to proceed. Shay Grant is the St. Francis Ministries Permanency Specialist who'll be giving us an update today.
Awful for the mother. Oh, we're present, ready, Your Honor.
Casey Zavala for Nathaniel.
Okay, what's new, Ms. Grant?
Initially, we had asked to be dismissed from the case. After speaking with the attorneys, we did agree to stay in the case for a little bit longer. Ms. Henderson is actively working on getting Nathaniel into Cal Farley's Boys Ranch. Just has concerns with Nathaniel's behaviors in the home. And then he's also had some behavior start up at school, which is normally, he doesn't have any problems at school, but that's where we are right now. It's just waiting on to see if she's able to get him in that Boys Ranch.
What is it that, I mean, just as a practical matter, what is it that we can do or offer to do between now and if he gets in?
As far as behaviors or?
No, I mean, what, in other words, we were ready to dismiss out child's at home. What can we do? What is it that we can do or we are doing to assist the family and if and when the child can get into Boys Ranch?
Right now, they've continued in family therapy, but that's really the only thing that they're doing. We've discussed to see if there's anything else that we could offer. I know they had talked about different extracurricular activities for Nathaniel, but that's really it.
Because if she gets him accepted at Boys Ranch, I mean, that's not gonna be a placement through the department, I assume.
That's correct.
So, Ms. Naranjo, does your client want us to continue in the case? I mean, so we can continue to provide that counseling, or?
Yes, Judge. My client would like to keep the department involved. There's been some real struggles with Nathaniel's behaviors and things like that. And the hope is that we can get him into Boys Ranch. But if not, I know I've discussed with my client that there may be a risk of the child having to go back into the care of the department.
Okay. I'm looking at our dismissal date is January 31st of 2025. So we're coming up on our drop dead date pretty quickly. All right, Ms. Zavala, anything to add?
Your Honor, I've spoken with Nathaniel. He, I think he acknowledges that there have been some behavior problems. He feels that he's started to improve since a recent discussion with Miss Grant. But there definitely are some struggles going on right now. Nathaniel wants to stay at home. We've had a talk about what he needs to do that. I know that that Jackson is concerned about, what happens if he doesn't get into Boys Ranch. It sounds like Boys Ranch may have some outpatient services that they may be able to get set up, and they're working on that. So Nathaniel wants to stay, but there are some definite issues. So we talked about working with Steve Jennings about specifically with Nathaniel about a plan about what he needs to do to show some improvement so that he can stay.
Okay, I mean, does he have, he's 12. So, does anybody posted a set of rules, in writing that he can look at on a day-to-day basis?
That was one of the things we talked about in our conversation yesterday, just coming up with a specific plan. I don't know that it's been done yet. That conversation was just yesterday.
Okay. All right, well, I certainly don't have any problem staying in the case until our dismissal date, but what happens then, at that point in time, we by law will have to do something in a final order in the case, either a PMC to the department or dismiss out of the case. So hopefully you will hear something from Boys Ranch pretty quickly. So I'll go along with it, and we'll just not extend things, but we'll just stay in the case. So our final hearing is set for January 21st of 2025. That'll be on a 9 o'clock docket. So I will continue the department as temporary managing conservator and continue his placement at home for the time being. And I'm not finding that there's a danger for the child to be at home. I just would find that we're just not quite ready to bow out yet. So need to keep monitoring. All right. I'll see y'all back towards the end of January 21.
Thank you, Judge. Judge, those were the only two cases that I had on your docket today, so may I be excused.
Yes, sir. Thank you. Y'all have a good day. Initial permanency hearing. We're conducting this through Zoom. We're live streaming, and Ms. Gooden is making our record. We'll go ahead and take announcements.
Daniel Trial for the Texas Department of Family and Protective Services. Michelle Slagle is my permanency specialist. We're present ready.
TD for Mom, Ashley Turner, ready, Judge. Hopefully she'll join us.
Brooks Barfield for Mr. Draper. He's present and ready.
Stacy Zavala for Draylen.
Hello, are you guys there? This is Ashley.
Okay, Ms. Turner. Yeah, we can hear you now. We've been trying to make sure you were there, but we can hear you now.
Okay. Okay.
All right, then. Did everybody announce?
I think so.
Okay. All right, then. What do we have new? Ms. Slagle?
Well, I did find out that Brian has started some parenting classes and some of his drug risk classes. He does have 6 parenting classes with Padre left and 2 with his drug risk. And he also did go drug screen for me on Thursday for a hair follicle, but that is not back yet. I checked this morning to see. And that's all that I've got that's new.
Okay. We are we doing in-person visits now?
Yes, they are. Ashley hasn't made it to, I believe the last 3 visits. I'm unsure of why. I thought she had went to inpatient Centacor, but I've not had any communication with her and she's here today. So I'm not for sure what the reason is on that, but Brian does make it to all of his visitations.
All right. When was the last drug test we did on mom?
Mom did a UA on October 17th and it was positive for methamphetamines.
Are we still doing in-person visits?
Yes, but like I said, she hasn't made it to the last 3.
What date in October did she test?
You're muted, Michelle.
I have tried to send her a couple of times this month, and she has not responded back to me to be able to go this month before court.
What was
Okay,
the date she went in October, Michelle?
Oh, I'm sorry, October 17th.
Okay. Okay, Ms. Turner, I'm gonna order you to go drug screen today, and you will need to be out there before 4 p.m. And that will be, when was her last hair test, Ms. Slagle?
In August.
Okay, that'll be a hair and UA. I'm gonna stop your in-person visits until we have a negative UA on you. And that's really not meant to punish you. It's meant to protect the health of the child.
Yes, ma'am.
Okay. So be out there before 4 today.
Okay.
Miss Slagle, you said Dad went for a hair follicle on Thursday?
Yes.
When was the last UA you had on Dad?
He is never a UA or a hair follicle for the department or St. Francis until last Thursday. So he's never UA'd at all.
Well, it's a problem. You know, Mr. Draper, you're doing well with other stuff, but I've got to have a clean drug screen on you. I mean, we've got to know what's going on with that. So I'm going to order you to go do the same today. Or excuse me, you went just last week. So we're just waiting for results. So
Judge, we'd asked for a UA today because he only did a hair follicle
we
last.
just did a hair. Okay.
Yes, ma'am.
All right. I'm going to order you to go do a UA today. You need to be out there before 4 o'clock. And same deal. I'm going to stop the in-person visits till we make sure we've got negative UAs on both of you. You know, again, it's not meant to punish y'all. It's just, this is a really young child. And if we've got positive drug screens going on, you know, that could be a health and safety risk to the child. So if the UA is clean, then you keep on doing your in-person visits.
Okay.
All right. Mr. Hammonds, anything today?
Judge, the discussion I had with Ashley yesterday, she understands she's got to focus on herself and get clean. And so I told her she needs to get with the caseworker, inpatient. If that's what they want, that's what she needs to do. So I think she's reached a point of cooperating with the department. She's been waffling back and forth. I told her, I said, this is not going to work until you get yourself fixed. So that's where we are.
All right. So, Ms. Turner, you went to outpatient, but you didn't stay. Why did you not stay?
I went to Plainview and I went to the Serenity Center. I didn't stay there because I was being ignorant and thinking, I just thought it was okay just to leave, but I talked to TPC here in Amarillo, and she referred me to go to inpatient at Centercore here in Amarillo, Texas. And they told me until I detox at the Northwest Texas Behavioral Center that I wouldn't be able to do their program for 30 days until I detox. So I just went to go see a doctor yesterday because they needed a note from a doctor saying that I was cleared for my pregnancy to go detox, because the detox wouldn't even take me either. So I got a letter from them on my phone through my email, and I'm hoping that if I go today to the detox center that they'll just take me from there, because I've seen a doctor and I've seen Hope Choice for proof of pregnancy, so I'm pretty sure that's all I need. So I plan on going to inpatient as soon as I can detox. And I also have an appointment on the 21st for a sonogram, so if they don't take me today, then I should be able to go by the 21st.
Okay, well, I cannot encourage you enough to go do that, especially since you're pregnant.
Yes, ma'am.
I mean, you know what can happen when you give birth to that child if you're still using. So, please, I hope you'll go get the detox done, and I hope you'll go in and you'll successfully complete rehab. But I am going to order you to do it. So,
yes, ma'am.
It's not voluntary anymore. I've court ordered you to go.
Yes, ma'am.
Okay.
And Judge, is that that's ordered to do inpatient? Is that followed by outpatient or just inpatient at this time?
Well, I certainly want to go do inpatient and then any recommended outpatient, because there typically is. All right, then, Mr. Barfield.
Your Honor, it appears that my client has kind of started his services. He'll go get his drug test today. I read the report, and it looked like he was getting slow to start, but it looks like he's on board now. And I don't have anything additionally other than he just needs to continue working his services.
All right. Ms. Zavala?
Your Honor, Kelly's been able to go out and meet with Draylen in person. He's doing great. My only concern and issue today was the drug screens and the visits, and that's been addressed.
Okay. All right, then, and I will continue the department as temporary managing conservator, and I will continue Draylen's current placement. I'm going to find that there would be a continuing danger to return the child home today. I've already said it, but I'm going to just reinforce it. I'm going to order Ms. Turner to go and do a hair and a UA test today before 4 p.m. And we'll stop her in-person visits until we get a negative UA. Same with Mr. Draper, except I'm just ordering him to do UA today, and stop visits until we have a negative screen. Order mom to go to inpatient rehab and recommend any recommended outpatient treatment. And then I'll see everybody back March 18th of 2025 on a 9 o'clock docket. We'll see how everybody's doing at that point. Ms. Turner, I cannot stress to you how critical it is that you go do this.
Yes, ma'am. I'm going to go do it because I need to. I'm more than encouraged to go do it because I really see that this has been a problem, and I don't want nothing more but to cooperate with you guys because I do want my child back.
And you want to be able to keep this baby.
Yes, ma'am. I do. I really do. And I'm going to because I have some tooth dental problems. My wisdom teeth are bothering me in Plainview at the Serenity Center, but that's no excuse for me to leave, and I understand that now. So I'm going to do everything in my power to go today and try to detox. That's like 3 to 5 days. And then from there, if they do take me, they can do the detox and I will go to inpatient for 30 days or however long they need me to.
I encourage you to stay as long as you can.
Yes, ma'am.
So
I agree.
I mean, and it's critical that you stop using for the health of your baby.
Yes, ma'am. Thank you.
All right, then I will see everybody back March 18th.
All right, thank you, Judge.
Good luck. Thank y'all.
Thank you, Judge.
Thank you.
Okay, then, who's gonna give us the update?
Ms. Slagle will, Your Honor.
All right, Ms. Slagle.
Sorry, I'm having to do it from my phone and I wasn't for sure how to get the mute off.
No problem.
Everything is going good. There is a few updates. Dad did screen a negative UA on March 7th, so his visitation has started back. I did get Ashley Turner's hair follicle back, and it was still positive, but she's only 60 days out from her sober date, but it was a low number of, I think, 1,700. So they're both, at this time, they're testing negative on UAs. Ashley has got her WAVE class scheduled to start on March 20th. They both started counseling with Jennings, and he's going to do couples counseling with them also. They have gotten a hold of Antonio Graves they're doing an outpatient screening today to start working with them on a relapse prevention plan and extra support. Brian is going to have to do another OZAR due to testing positive, and we've got the referral in for that and just waiting for that to be scheduled. Other than that, I mean, the house is looking great. They've got Draylen's room ready and the baby's room ready. They're redoing some things to make it more of a safe environment. Also, Ashley was wondering, because she hadn't did her parenting classes yet, but she did parenting while she was in outpatient or inpatient rehab. And her psychological had stated that she needed to do the Padre class. She didn't know if the parenting classes in her inpatient rehab could count for that.
You know what the curriculum was? I mean, do you think it covers
I've got
the age children that we have? I mean,
I've got the certificates, but I haven't been able to go over them and look exactly. But she's got about 5 or 6 of them, and they're all about 4 to 6 hours each. When she was in rehab at Serenity, I know they did, I believe, 3 to 4 hours of just parenting classes a day, and she did complete her inpatient rehab.
okay.
Ms. Slagle, did you mention, I believe, a while ago, Fatherhood Fire?
No, I've not mentioned that. No, but that is something that we can look into for Brian.
Okay, all right. I thought you had mentioned that as something that y'all were looking into or trying to get set
Well,
up.
they are doing an assessment with Antonio Graves today, so they can start an outpatient rehab with them to develop another relapse prevention plan, since they are living together now.
Gotcha.
So he's going to do an assessment for them and get started on what services he can provide for them.
Okay, sorry, I must have misunderstood you. I appreciate it.
That's okay. And Draylen is also living with his grandparents right now. We did a kinship placement, and then they got licensed through the Bear Foundation. So he's there. He's just now starting Mother's Day out, I believe, this week. So as of right now, he's doing good. Still up to date on all of his medicals and dentals, and doing visitation with parents. And as far as I know, visitations have been reported to be going good.
All right, then.
Oh, and I'm sorry, Judge. He did finish his rational behavior also after the court report was made.
Okay. All right, Mr. Hammonds.
Judge, I have no questions.
Okay. Then Mr. Barfield.
I don't have any questions of this witness, Your Honor.
Okay, and Ms. Zavala.
Your Honor, no questions, just an update when you're ready.
Okay. All right, let me just go back. Mr. Hammonds, anything to discuss today or any questions on behalf of your client?
I'd like to talk to Ashley just briefly.
Sure.
Yes, sir, I'm here.
Ashley, when did you complete the inpatient?
I'm not sure. I think
Well,
February 6th, February 6th, I'm sorry.
okay. And afterwards, are you going to any aftercare type classes?
We're going to do an assessment today for an outpatient because I had spoke to my sponsor and tried to get through like a Zoom outpatient through the Serenity Center, and I haven't gotten a call back or anything from him, but she did send my email and my number, and I just haven't heard anything back from him, so I'm just guessing we should go through Antonio Graves, which is somebody that's going to help me with Padre classes as well, but we're going to go today from like 12:30 to 2 and then see where he can get us referred to.
Okay, and do you presently have a vehicle?
Yes, sir.
And are you seeking employment?
I am right now, yes. I'm just going to a couple of interviews, but I mean, if I can't get a job, then I'll just have to sit home and have this baby.
Okay, well, and how many months pregnant are you right now?
I'm 32 weeks, so like 7 months.
Okay. Tell me when this is over, give me your current phone number. The one that I had, I couldn't get a hold of you. Just so
Okay.
we can stay, just so we can stay in contact. It's important that you keep doing what they want you to do. We've got a final coming up, so, work toward, all I can tell you is work toward getting employment so you can show you can support these kids.
Yes, sir.
Okay. I have nothing further, Judge.
Can I write your number down?
Yes, I will give you my number. I have no problem. 806.
Okay. I will give you a call. Thank you.
All right. Thank you. Nothing further, Judge.
Okay. All right, Mr. Barfield.
Where'd he go? Oh, there you are. Brian, please unmute.
Okay.
Mr. Draper, do you have any questions about what you need to be doing?
No, sir.
Okay. You did hear Mr. Hammonds advise his client that, time is ticking away. So, if you have any questions or concerns, now's the time to bring it up.
No, my only question is if it's possible you would ask if we could have 2 hours because we're doing our visitations together.
That's why I'm asking you questions. So, you're requesting to have a little more visitation, and while you complete your services. Is that correct?
Yes, sir. Because
Okay.
I just went to I just came back from a counseling meeting right before court. I got one more in before we went to court.
Outstanding. We'll keep busting those services out. Looks like you've turned the corner. Any other questions you have for the court today?
No, sir.
Okay. Thank you, sir. Good job.
Good. Thank you.
All right, and Ms. Zavala?
Your Honor, I met with Draylen in the home with grandmother. We had a nice long talk. He seems very comfortable in the home. The home's very appropriate. I think grandparents are both protective of Draylen and supportive of the parents. And I had a conversation with grandmother that I just want to emphasize here that while parents, my biggest concern was no shows or positive drug screens. It looks like they're now appearing and that those UAs are clean. And so that takes away my concern about the visitation. But I do want to make sure parents understand that if you show up over there unannounced and unscheduled, that can be a problem that could really lead to him being removed. And we don't want that. He's comfortable there. He's very, very loved and taken care of there. And it sounds like parents are doing what they should, and that won't be a problem in the future.
In your honor, sorry, as far as the upping the visitations, we are good with that right now. As long as parents keep working their services and we don't have any more issues with drug screens, and they make their drug screens when asked. But kind of same problem when we have had this type of drug use. If positives pop back up, visitations, it can affect their visitations.
Correct. So, Mr. Draper and Ms. Turner, y'all are moving in the right direction, and I'm very pleased. I'll increase your visits to the 2 hours a week supervised by St. Francis right now. As long as your drug tests, those hair levels continue to drop and UA stay negative. If we get a positive UA or we get a hair test that's gone back up, then we've got a problem. I mean, we've got a big problem at that point. But, as long as we're trending in the right direction, I'll be fine with that. I'll also be fine at some point with seeing if placement would be willing to do some supervising of some visitation. That often is very helpful when we get to the point where maybe we're starting to look at reworking him into the home, where we can increase the amount of time you guys have. Maybe you can go over there, help out a little more. And then, as we move into unsupervised and all that. So the fact that we've got the child with family right now is a really, really good thing. But you can't take advantage of, maybe their good graces. So don't ask them for something that's outside of the rules. We don't want to jeopardize where the child is placed right now. So just don't put them in that position.
Yes, ma'am. Thank you, Judge.
And they've been told they can't just let you come and go whenever y'all want either. So let's up the visits to 2 hours a week for sure. And as long as things continue in the right direction and we're doing really well, then, these people all know they don't need necessarily to have my blessing to increase those visits. They know what the criteria is, and so, we'll slowly ramp that up as long as we're getting these services worked and drug tests are staying negative. So
Okay, thank you.
It's, the most critical thing for you guys is the drug use. That's the single biggest issue. So sounds like you're doing good on getting your home ready. You're doing these other things. That's all good, but we've got to stay away from the drugs. So
yes, Judge, thank you.
Okay. All right then. Ms. Zavala, any further recommendation or anything?
No, Your Honor, he's doing very well where he is.
Okay. Okay, then for today, I'm going to continue the department as temporary managing conservator, and I'm going to continue his current placement. I find a continuing danger to return the child home today. But I also find parents are in compliance with their service plans. And we're going to increase the visits to the 2 hours a week supervised as long as we have negative drug tests. Okay, I'll see you all back. It's our final, June 3rd. And that's going to be on a 9:00 docket. So y'all got a late start on these things. You're going to have to really, really work hard to get things finished. Ms. Turner, when are you expecting?
My due date is May 10th.
May 10th? Okay.
Yeah.
All right. I can't stress again, obviously, how important drug tests are between now and then, and because you know what's going to happen if we get a positive drug test.
Yes, ma'am.
Okay, then let's all work towards having a healthy baby and keep working towards getting Draylen home. All right, I'll see you all back June 3rd.
Thank you, Your Honor.
Thank you, Your Honor.
Okay.
Thank you.
Judge, may I speak to Brooks before he gets away?
I guess that's up to Brooks. Mr. Barfield,
Yeah, I'll talk to him.
available?
I'll talk to him.
Okay, I'm gonna put you into room 1. Mr. Trout, you can go back to 1, and I'll start getting everybody in on our other case.
Thank you, Judge.
Thank you, Judge. Ashley, please give me a call. Thank you.
Yes, sir, I will. Thank you.
Oh, have y'all set a mediation date on this?
We haven't, but if we can get one order, yes, ma'am.
Well, standing order. So if you need us to assign somebody, we'll assign a mediator.
Yes, ma'am. That's what I mean.
Okay. All right. We'll find out who's on the list and we'll let you know.
Yes, ma'am.
Okay. Thanks.
Thank you, Judge.
I'm going to step away for just a second.
Permanency hearing. We're conducting this through Zoom. We're live streaming, and Ms. Goodman is making our record. All right, we'll take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. Cassie Kopic is my permanency specialist. We're present ready.
Stacy Zavala on behalf of Zelenia.
Okay, what do we have new? I know we're looking for them in El Salvador, but no luck yet, huh?
She did, Zelenia did give me a phone number for the parents, and I did reach out by text, but I haven't got any response back. Zelenia is doing fairly well in her foster home. They do continue to have issues with her hygiene, and she like will spit on the floor and stuff. Foster mom has been having a little bit of problems with her with the cell phone because she don't allow her to have it during the night or take it to school with her because she's, you know, on it all the time. But otherwise, I mean, she's doing pretty good.
All right, and nothing new as far as from the consulate or locating parents. I know I read that there was a phone number that maybe you got through a relative.
The Zelenia gave me a phone number, but they haven't reached back out to me, so I don't know. The phone number is kind of weird too. It's like too many numbers, it seems like, but it will deliver through a text.
Okay. All right, Miss Zavala, anything to report?
Yes, Your Honor. Zelenia's doing pretty well in placement. She's in a school that's letting her kind of catch up. She's moved from 9th grade to 10th grade type classes. And hopefully she will continue to make some pretty significant progress in that. Foster home does have rules about the phone, which I think are a pretty good thing. I'm not sure Zelenia feels that way, but her English is getting way better. She's been very clear with me that she does not want to go to El Salvador. We started talking about extended care and some options for that. And then foster mom is planning to get her in driver's ed, I think in January. But whatever St. Francis can do to help with that would be great. But I do recommend that placement continue.
Okay. Have we identified any other family members that live in the U.S.?
There was the aunt that she was living with when she came into care, and then there was some in Houston that the investigator had contacted and didn't want to take her as a placement.
Okay. So we've contacted whoever we know about.
Yeah, and those were the only two people that, because we can't run like diligent searches on them because they're out of country, but those were the only ones that we had on our stuff that got run.
And I did want to note the phone number would be longer because you've got to do the country code when you dial out. So that may be why there are those extra digits.
Okay.
And Judge, we'll work on an affidavits of inability to locate on parents. I think Kim sent an email out last week on that.
Yeah, and Ms. Copic, just for the record, I mean, have we tried anything on Facebook or any social media?
I did some name searches, but I didn't really find anything, but I can look more into that.
We just strangely had some success finding people that way in the past that are out of the country, but anyway, we'll keep looking. Okay. I will continue the department as temporary managing conservator, and I'll continue her placement. Fine, there would be a continuing danger to return her home, and in fact, couldn't even possibly do that right now since we don't know where parents are. Our next review hearing will be March 18th, 2025, and that'll be on a 9 o'clock docket. All right, thank you so much.
Thank you, Judge. Thank you, guys.
I don't know where we're getting feedback. We are here today. Jerry, I think it's coming from you. I'm going to mute your device real quick. All right. We are here today set for our final. We are conducting this through Zoom under a finding of good cause and agreement of the parties. We're live streaming. Ms. Goodman is making our record today. Okay, we'll go ahead and take announcements.
Daniel Trial for the Texas Department of Family and Protective Services. Will present ready, Your Honor.
Gary Morales for respondent mother Sabrina Goldberg, Your Honor. She is incarcerated at the Park County Jail. Ready.
Stacy Zavala on behalf of Cheyenne.
Okay, Mr. Jackson has, I think, filed a report concerning the unknown father. He had a conflict today, but I was looking to see if that had made its way into Odyssey yet. Yes, it has. And so if y'all haven't seen that, you may want to pull it up and just take a look at it with respect to his efforts concerning an unknown father. Okay, I do want a bench conference with council, so let me put us in there real quickly. Okay, I'm gonna move some department folks into that breakout room. All right, and Ms. Zavala has had an opportunity to talk with Miss.
And Judge, just so everybody knows, before we get started, after the bench conference, after I talked to my clients, they would still like to proceed the way we're asking. So.
Okay. All
And
right.
then Daniel, I sent you a message. Did you see that?
I did. Thank you, Stacey.
Okay. You've got
33 minutes.
Yep. 33 minutes.
Yes, ma'am.
All right, then. How many witnesses you have?
2, Your Honor.
Okay, and anybody else have any witnesses that they intend to call today?
No, Your Honor.
Okay, then if those who are going to testify, please raise your right hands.
Yes.
Martinez and Ms. Butler. All right, very good.
And Your Honor, I hadn't thought about this. Cheyenne is present. I don't know if it would be possible to go off of YouTube. I know it's final, so I don't know.
I'm sorry, Ms. Vaughn.
I know it's a final, so I don't know if that changes anything.
I would prefer to just approach that topic if there's going to be some sensitive information about the child that is going to be discussed. So you could raise your motion at any point in time, but because it is a final, I think for most of this, it probably does need to be open court. So you can raise that motion at any time you need to do that or feel like it's appropriate. Okay.
All right.
You call first witness.
Call Courtney Butler, Your Honor.
All right, Ms. Butler, you've been sworn, so you may proceed.
Ms. Butler, would you state your name for the record, please?
Yes, Courtney Butler.
And Ms. Butler, how are you employed?
With the Department of Family and Protective Services.
And in what capacity are you employed at this time?
I'm the faith-based community engagement specialist.
And are you familiar with the case involving the child?
Yes, sir.
And were you the investigator at the time on this case?
Yes, sir.
How did the department become involved in the case involving this child?
We received an intake on November 11th, 2023 in regards to domestic violence between Cheyenne and her then boyfriend, Jess Colander.
And during your investigation, did you find out who the mother was?
Correct.
Okay. And what was her name?
Sabrina Culliver.
Okay. And were you able to find out a name of the child's father?
No, sir.
Okay. During your investigation, were you able to go, you met with the child, correct?
Correct.
And you met with the child at was it a hotel that she was living at?
Yes, sir.
Okay. And who was she living with at the time?
She was living with her then boyfriend, Jess, his brother and grandmother at the time.
Okay. Then were you able to meet with the mother of the child?
Yes, sir.
Okay. And where was the mother at the time?
She was currently in inpatient rehab at Synacor.
And did you have conversations with the mother regarding the allegations?
Yes, sir.
Okay. And how did your conversations with mother go?
I informed her of the allegations of domestic violence. She stated that there was prior domestic violence prior to her going into inpatient rehab, and that she was concerned for her daughter and her granddaughter at the time.
Okay. How long had mom been in rehab at that time?
I do not remember off the top of my head. I do believe it was a short amount of time, just a few weeks.
Okay. Had mom at the time she'd given consent or permission for the child to live with the boyfriend's grandmother?
Yes, correct.
Okay. During your conversations with mom, did she decide to revoke that consent and essentially wrap her the child?
Yes, sir.
And was that based upon her concern for her daughter and grandbaby living in that situation?
Yes, sir.
And we did not have any information on a dad or possible family at that time?
Correct. No information.
Well, I say possible family. There were some people that came forward that wanted to be placement, but at the time were not appropriate. Is that correct?
Correct. Yes, sir.
Okay. So due to mom revoking her consent of the child staying where she was and stating that she wanted her child and grandbaby taken out of that situation, was it best to remove the child and in the child's best interest at the time?
Yes, sir.
And is that what you asked the court to do?
Yes, sir.
After removal was granted, did you have any more conversations with mom about possible family or who dad was?
Yes, she informed me that she did not know who Cheyenne's father was. It was a one-night stand. And she also informed me that there was a possible friend that her daughter could stay with. And I reached out to that friend as well.
Okay. But at the time, child was placed in foster care.
Yes, sir.
Okay. And when you went off of the case, how was the child doing?
She was doing well in her placement.
Okay. And again, you do believe due to mom agreeing to wrap her the child and the situation the child was in, it was in the best interest of the child to remove her from that situation?
Yes, sir.
I'll pass the witness, Your Honor.
All right. Mr. Morales.
No questions, Judge.
All right. Mr. Jackson has filed his report and obviously giving everybody the information. Has everybody had an opportunity to look at that?
Yes, ma'am. I looked at it a while ago.
Yes, Your Honor.
I'm going to take judicial notice of that report as to his efforts at locating or trying to identify the unknown father. And would like to make that a part of this record. And that is, so to be specific, that I'll take judicial notice of the ad litem attorney's report regarding an unknown father filed in this case on today's date, filed by Mr. Jackson, who was appointed to represent the unknown father. All right, Ms. Balla.
I have no questions of this witness.
Okay, Mr. Trout, anything further for this witness?
Nothing further from this witness, Your Honor.
All right, any objection to Ms. Butler being released at this time?
I have no objection, Your Honor.
No objection.
No objection.
Okay, Ms. Butler, thank you. You're free to go.
Thank you, Judge.
Thank you, Ms. Butler.
Good. All right, so you can call your next witness.
Tamara Martinez, are you familiar with that case?
I am her permanency specialist.
When St. Francis, have you been the permanency specialist the whole time on this case?
Yes.
Okay. When you first receive a case, how do you start working the case? What is the first thing you do?
We go over the investigation of the case and evaluate the concerns, and then we meet with the parents and discuss a plan.
Okay. And when you say discuss a plan, what do you mean?
And we go over the concerns of removal. In this case, we went over the concerns of Sabrina's drug use. We developed a family plan of service for her.
And can you tell me what a family plan of service is?
It's services that we ask the parents to complete to mitigate the reasons that their child came into care.
Okay. And was that generated in this case?
Yes.
Okay. And did you go over this family plan of service with mom?
Yes, I did.
Did you, were those family plans, was that filed with the court?
Yes, it was.
Were those made orders of the court?
Yes.
Did you receive the exhibits I sent out?
Yes, I did.
Okay. We'll start with exhibit number 1. Can you tell me what that is?
It's the family plan of service.
And is this accurate copy of the family plan that you generated for mom and filed with the court?
Yes.
Was this submitted to the court on January 9th, 2024?
Yes.
Your Honor, I'd ask to admit exhibit number 1 is the family plan, certified copy of this family plans of service that was generated from mom that was just testified to.
No objection.
No objection.
All right, petitioner's exhibit 1 will be admitted.
Thank you, Your Honor. And can you look at exhibit number 5 for me, please?
Yes.
And can you tell me what exhibit number 5 is?
Status hearing order.
And during the status hearing, is that when family plans of service are made in order of the court?
Yes.
And that was done in this case, correct?
Yes.
Your Honor, excuse me. And Ms. Martinez, on the first page of the status hearing order 1.2, is it marked that mom appeared at that status hearing and along with her attorney?
Yes.
Your Honor, I would ask to admit exhibit number 5 is the certified copy of the status hearing order from this court that was testified to.
Any objection?
No objection.
No objection.
All right, petitioner's exhibit 5 will be admitted.
Thank you, Your Honor. Ms. Martinez, during this case, has mom worked her family plans?
No.
Has mom, what services was mom required to do during this? Sorry.
She was required to do a psychosocial evaluation, individual counseling, parenting. She was asked to do an OSAR evaluation, maintain stable housing, maintain employment, random drug screens.
Has mom started or completed any of those services?
She's completed her psychosocial evaluation. She started counseling but did not complete it.
Okay.
In regards to her OSAR, she had completed Synacor, but did test positive after Synacor, so she was in need of an OSAR evaluation.
Did she do another OSAR after that?
No.
Did she do her parenting classes?
No.
Did she have any recommendations from the psychosocial?
Yes.
Did she complete those recommendations?
No.
And what were those recommendations? Let me ask you this way. Was it recommended that she continue to attend counseling and address any issues?
Yes.
Did she finish that?
No, she did not.
You've already stated that she did not complete a parenting class, which was also a recommendation. Is that correct?
That is correct.
She was recommended that she attend the assessment through the OSAR and follow those recommendations. You said she completed one OSAR, but relapsed and was required to do another. Is that correct?
She didn't ever do an OSAR. She completed Synacor, relapse, and then did not complete an OSAR.
Okay. And did she ever get set up in an AA or NA or Celebrate Recovery?
No, she did not.
When's the last time mom drug screened for you?
Her last drug screen was May 23rd.
And mom has been incarcerated, is that correct? And is currently incarcerated?
Yes.
So in the last few months, she has not been able to drug screen due to incarceration, correct?
That's correct.
Okay. Prior to her incarceration, was she consistent with her drug screens or did she miss some?
She missed some.
And the drug screens that she did make, were they concerning?
Yes, they were.
Did mom ever test negative on any drug screens?
She tested negative on one oral swab right after she completed Synacor.
Okay. But other than that one oral swab, the rest of the results were concerning throughout the case.
Yes.
Okay. Did mom have a stable housing?
No, she did not.
Did she have a stable job?
No, she does not.
How has mom been having visitations with the child?
She has not had visitation with Cheyenne since she became incarcerated, and I want to say before that they were starting to get a little sporadic.
Okay. And sporadic, there were virtual visits?
Yes.
And she was making some, not making some?
Yes.
You stated that she started counseling, but has she ever finished her counseling?
No, she has not.
Did mom stay in constant contact with you throughout the case?
Not always, no.
Do you know, when's the last time you talked to mom?
I spoke to her at the Randall County Jail at the end of October.
Okay. And is mom currently in Potter County Jail?
Yes, she is.
Okay. Did mom tell you why she was incarcerated?
She was incarcerated at Randall County for a possession charge.
And did mom, to your understanding, did mom tell you whether she took a plea on that or not?
Yes, she told me she was going to do probation and that she had to go to safety.
Okay. Your Honor, I would ask to admit exhibit number 2. It is a certified copy of the indictment and the order deferring adjudication for the case out of Randall County that was just testified to.
Any objection?
No objection.
All right, petitioner's exhibit 2 will be admitted.
Thank you, Your Honor. And do you know why she's in Potter County Jail?
For a different possession charge.
Okay, and she has not taken a plea on that at this time. Is that your understanding?
That's my understanding.
Your Honor, I would ask to admit exhibit number 3, which is a certified copy of the indictment on the case mom is in Potter County for.
No objection.
No objection.
All right, petitioner's exhibit 3 will be admitted.
Thank you, Your Honor. How is the child doing at this time?
Cheyenne's doing good. Has her ups and downs.
Okay. Is she doing well in her placement right now?
Yes, she is.
Okay. Is the department still actively looking for a possible family or for an adoption motivated family for the child?
Yes, we are.
And looking for a family that would want to take in Cheyenne and her child. Is that correct?
Yes.
Okay. Department still having hope that they will be able to find that, and is Cheyenne open to that option?
Yes.
Have you had conversations about that?
Yes, we have.
Okay. As to dad, have you had conversations with mom as to who the possible father is?
Yes, I've talked to her about it.
Okay. Has mom given you names?
No, she has not.
Okay. Did she state a name and then say that no, he's not the dad, and then back and forth on whether she would or would not tell us who it possibly was?
Yes.
Did we run a punitive father registry search or paternity registry search?
Yes.
And Cheyenne was born in Louisiana, is that correct?
Yes.
Was the search fruitful? Did it come back with any names of possible fathers?
It did not have any names.
Your Honor, I would ask to admit exhibit number 4 is a certified copy of the punitive father registry certificate that was filed into this case from Louisiana, stating that nobody had intended to accept paternity of Cheyenne.
No objection.
No objection.
All right, petitioner's exhibit 4 will be admitted.
Thank you, Your Honor. And due to that, Ms. Martinez, we have not been able to find who the father is in any paternal side of the family. Is that correct?
That's correct.
Is the department asking today to terminate the parental rights of the mother, Sabrina Colbert, to the child based upon mom's failure to work services?
Yes.
And mom's inability to take care of the child at this time.
Yes.
And do you believe that's in the best interest of the child to give her the option and the possibility of being placed in a foster home or possibly adopted?
Yes.
And are you also asking to terminate the parental rights of the unknown father based upon failure to register with the paternity registry?
Yes.
And do you believe that's in the best interest of the child?
Yes, I do.
I'll pass the witness, Your Honor.
All right, Ms. Morales, any questions?
No questions, Your Honor.
All right, Ms. Vala?
Ms. Martinez, has Cheyenne talked to you about wanting to see if she can get a home study on her boyfriend's grandmother who has now moved to Oklahoma?
She had mentioned wanting that the grandma that Callie had wanted a home study. I told her I hadn't heard from Callie, and I explained the safety concerns in regards to that.
Okay, so I understand that St. Francis has some concerns about the home study. Does it make a difference to your position to know that Jess would not be in that home in Oklahoma?
It still raises concerns, even if he's not in the home, how protective she would be of Cheyenne and Amelia.
Has Cheyenne talked to you at all about wanting potentially to have some phone calls or Zoom conversations with mom if she is no longer incarcerated, even if she's terminated?
I do not recall her mentioning that to me.
Okay. I pass the witness.
And just clarification, Ms. Zavala, this is the same individual that they were living with at the time of removal, correct?
Yes, Your Honor. Cheyenne is asking if there could be an ICPC home study on Callie, who is the grandmother, who now lives in Oklahoma, and she is telling me that Jess no longer lives with her.
Okay. Well, obviously, if we order the ICPC, they will determine who all resides in that home, and so. All right. Anything further, Ms. Zavala?
I have no further questions of this witness.
Okay. All right. Anything further of this witness, Mr. Trout?
Nothing further, Your Honor.
All right, is the department rest?
Department rest, Your Honor.
All right, Mr. Morales, anything to present today?
Your Honor, I have no witnesses at rest.
All right, and Mr. Morales, since this is a final, Ms. Kohler is aware of this today, is that correct?
Yes, correct, Your Honor.
All right, and she did not request to be present today.
No, Your Honor.
Okay. All right, then Ms. Zavala, anything to present?
No official witnesses, just some requests by Cheyenne.
All right, Ms. Zavala, you can go ahead.
As already stated, she would request a home study on Callie, and I believe we've got her full name. And then if mom is terminated today, Cheyenne understands and agrees that mom is not in a position to take care of her. She also understands that while she's incarcerated, there won't be any contact. She is asking that if mom is released prior to Cheyenne turning 18, even if she's been terminated, if Cheyenne could have phone or occasional Zoom contact with her.
All right, what, in fairness, let me just ask what's St. Francis's position on that?
Usually, Your Honor, our position is we do not facilitate, or St. Francis does not facilitate post-termination contact with parents at that time. I haven't had the full conversation with them on this situation, but normally that is the stance, is that we don't facilitate contact at that point. But with the child's age, we can have conversations about it, and I don't know that it'd be a huge issue if and when mom gets out of prison and what circumstance she is in at that time.
So let me just counsel, it would be true, correct, that even though mom's rights may be terminated, that at any time if the child requested that down the road, we could certainly entertain that idea. It's not necessarily something that has to be determined today.
Correct, Your Honor. A lot of it would depend, I believe, on how mom is doing at that time. Throughout the life of this case, we've had issues with the drug use and instability. Depending on mom's situation, when she gets out of jail, that would be visited.
All right, Ms. Zavala, you have a recommendation?
Yes, Your Honor. I do believe at this time it would be in Cheyenne's best interest for her mother's rights to be terminated, as well as any unknown father. And I do think it would be, if mom is released while Cheyenne is still under 18, that it would be good for us to look at the situation at that point to evaluate whether contact would be good for Cheyenne or not. But I do know that that's what she would like.
Okay. All right, everybody close.
Close.
All right. At this time, then I do find by clear and convincing evidence that it is in the best interest of the child, terminate the parental rights between the child and her mother, Sabrina Kohler, based on Texas Family Code, section 161.001, subsection B1, the N and the O grounds, and the best interest under Texas Family Code 161.001, subsection B2. I find also by clear and convincing evidence it's in the best interest of the child to terminate the parental rights between the child and the unknown father based on his failure to register with the paternity registry under 161.002, subsection B2. At this time, I will name the Department of Family and Protective Services as permanent managing conservator. I will continue Cheyenne's placement. I'm going to dismiss all court-appointed attorneys after the appropriate de novo and appellate timeframes expire, with the exception of Ms. Zavala, who will remain as the child's attorney ad litem. Counsel, do be aware your de novo timeframe does begin to run since I've rendered an open court. And please do not file a notice of appeal if you're instructed to do so until a final order has been signed and adopted by the referring court. I'm going to go ahead and order the ICPC home study on Callie Melier. They will obviously determine who all lives in that home. We'll take a look at it. I just want to say, Cheyenne, understand those can take a long time. You know, we're talking months and months. So it's not, I don't want you to think that this is going to be something quick, because it's not. So just keep doing the best that you can where you're at, but we'll get it started. But we have to have the cooperation of people from Oklahoma. So these interstate home studies, they just take a while. All right. I'm going to reserve any kind of ruling on post-termination visitation between Cheyenne and her mom, because I feel like that's an issue we can address at any point in time. It's impossible to have that happen right now. So let's just wait until the question or occasion arises, because it could be quite some time before that would even be feasible. So, Cheyenne, I'm not saying no to that. I'm just saying there's really not much reason to decide anything about it today. Okay. All right then. I appreciate everybody's time and efforts. And for those of you that will still be involved, we will have a review hearing February 13th of 2025, and that'll be on a 9 o'clock docket. All right, I appreciate it. Thank you all very much.
Thank you, Honor.
All right.
Thanks, Martinez.
I know we're up against our time right now, but we're going to take just a quick recess for Ms. Goodman's benefit as much as anything. I'll go ahead and let everybody in. I don't know if y'all need to do any visiting or any talking about this. Okay, case. Mr. Eldridge, are you expecting her to attend?
I spoke to her the other day when we were supposed to do the mediation. She didn't want to sign a relinquishment, and so that's why we're here. I haven't been able to reach her this morning. I've called and it goes straight to voicemail. My secretary, she usually responds to emails. We sent her an email this morning trying to get a hold of her, and my secretary's working on it right now. Told her to call and send her another email and see if she'll respond. I thought she would participate, because otherwise we'd have done the relinquishment. And I sent her notice of this hearing on August 21st.
All right, did your notice say that it was at 11:30 or at 1:30
Said 9 a.m.
on the 9 o'clock docket?
Yes, ma'am.
Okay.
I guess I just looked at the time wrong. I apologize. I try not to be.
No, I'm just trying to determine whether or not we have a problem with what time she was given, but she's not logged in at all this morning. So at any point in time on my docket this morning, she's not come into the waiting room.
Now, the letter I sent August 21st said 9 a.m.
We're here today set for our final in this matter. We are conducting this through Zoom under a finding of good cause and agreement of the parties. We are also live streaming, and Ms. Goodman is making our record. Okay, we'll go ahead and take announcements.
Daniel Trout for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Your Honor, I'm Tate Eldridge. I represent Ariana Galloway, the mother in this case, and I'm present. I have spoken to her, but we haven't been able to reach her this morning, and I don't believe she's logged on.
Bill, you're muted.
I apologize, John. William Taylor, appointed to represent Joshua Fletcher, father of the child. I'm present and ready, and he has signed a relinquishment and is not present.
Stacy Zavala on behalf of Audrey, who goes by Hazel.
All right, then. Just for the record, then, Mr. Eldridge, you gave notice to your client of this final hearing, and your notice to her indicated that the docket time was at 9 a.m. Is that correct?
Yes, Your Honor. I sent that out on August the 21st, 2024. We sent it to her by direct mail and email. Our best communication with her has been by email. We've had a hard time getting her on the phone and stuff, but email has worked pretty good. We sent it both ways, though.
All right, and I did start my docket promptly at 9 a.m. this morning, and we've been working our way through the docket all morning, and she has not logged in nor been in my waiting room at any point in time this morning. So she is not present at this time, and I will, of course, watch the waiting room just in case. But she has not been here at all this morning. So,
and I guess just to kind of cover myself a little bit, I had it down as this hearing down as 1:30. I spoke to her last week and a half ago about a mediation we were going to do to see about termination. It was an all or nothing kind of case, so she wasn't going to sign a relinquishment. I don't have a letter in here other than the one I sent on August 21st. I guess I'm worried that I told her 1:30 since I had it down at 1:30. So that's my only concern, Judge. I don't know what to do with that. I don't recall telling her that. I do have the letter that I sent in August. So that's what I'm worried about, that I messed it up because I had it wrong on my calendar. So I don't know what you want to do with that, but I thought I ought to bring it up. I don't have anything in writing where I told her 1:30.
our dismissal date in the case is November 29th. What I will do is if she has not logged in by the time we conclude testimony in this case, I will reserve my ruling. And if she appears before the court at 1:30 today, we would just, we'll take testimony and I will recess this morning, and then I won't issue my ruling. So if she shows up at 1:30, we will just be in recess in the case, and then I will set another date And she can come in and participate. And that way, Mr. Eldridge, would have the ability to call her as a witness or anything like that that you need to do.
Okay, yes, Your Honor. I apologize for the mix up here. It's my fault.
No, I mean I have some concern that if your office did tell her 1:30 that that could account for why she isn't here right now. So I do have some concern about that, but she was also given notice that it was on a 9 o'clock docket. She was not present. I'm looking, I don't think, at our prior hearing.
I sent her a detailed letter about what we discussed at the last hearing. I believe it's probably August 21st. I don't have it. That's the day I sent the letter, and I wrote her a letter saying, here's what happened, and here's what you need to do, and here's the next date.
Okay. All right, well, we're going to proceed since you were present on her behalf and can question witnesses. So, Mr. Trout, who's your first witness today?
Yes, Your Honor, and before we start on that, just for the court and for the record, and Mr. Elder kind of alluded to it a little bit, mediation was ordered in this court per the standard, and the court did put in an order for us to do that. We discussed the case multiple times. We were too far apart and did not see a conclusion going to be made out of mediation. Mr. Elder and I continued to talk on it to see if we could get to a just weren't. So the mediation did not take place due to that, due to time and resources, not wanting to waste them. So we did continue those talks, but we're not able to get anywhere. So just so the court knows, that is why we did not go through with the mediation that was court ordered.
And I confirm all that, Your Honor.
All right. Well, I trust that you all have a pretty good idea whether you're going to get there or not. So that's fine.
In light of that, Your Honor, my first witness is Sasha Watson. And how are you familiar with that case?
I was the original investigator on the case.
How did the department become involved in the case involving this child?
It was a case regarding medical neglect and neglectful supervision as well.
Okay. What were your first steps when you received the case?
I did a lot of searching and seeking out to find Miss Ariana and both of the children, in which there was, it did take maybe almost about a month before I was actually able to make contact with Miss Galloway and the two children. And so find the families, assess the children, and talk to mom and try to talk to the fathers of the children as well.
Okay. And you stated mom's name is what?
Ariana Galloway.
Okay. And who was determined to be the father?
Joshua Fletcher.
Okay. Were you finally able to make contact with either parent?
Yes, sir.
And where were you able to find mom?
She was living in the home with her mother at the time.
Okay. And did you discuss the allegations in which you were investigating?
Yes, sir.
Okay. And how did those conversations go?
She reported that she was not present when it was a toenail injury that was untreated and unexplained. However, in doing the investigation, it was found that the children had not been to doctor's appointments since infant appointments. And so mother did acknowledge that the children hadn't gone to the doctor. She did set appointments a little bit further out. It was around March or so that I received the case. However, the appointments that she did schedule for the children were out in June. And so we discussed that. She did not have an answer for how the toenail happened. Boyfriend at the time, father to her other child, he also discussed the same thing and not knowing how the toenail injury occurred. We were able to, however, get her at least scheduled for medical appointments. But before those appointments occurred, the children were removed from the home. The other alternative intake that came in was regarding some concerns of drug use.
During your conversations with mom, did y'all discuss any alleged domestic violence within the home?
Yes, we did. Mother did allege that there was some domestic violence between her and the other child's father. However, there were there were no, police reports or anything entailing that there had been, but they were separated at that point and not living together.
Okay. During those conversations that mom told you there was domestic violence, did she mention whether the children were present when those incidents happened?
Yes, sir.
Okay. Were you ever able to meet or talk to Joshua Fletcher?
Yes, sir, I did.
Okay. Was that before removal or after?
It was after removal.
Okay. Were you able to find him during the investigation stage?
I was not. He was in the state of California at the time and returned to Amarillo after the removal was done.
Okay. So at that time, even with concerns in mom's house, placement with dad when possible because he was out of state at the time, was he willing to try to come get the child, or?
When I spoke with him, we went over all the paperwork. He was willing to do what was necessary to get, custody, control, possession of his child. However, afterwards, it was placed into the hands of St. Francis. So I'm not sure if he concluded with going through the process of doing what he needed to do or if he failed to do so.
Okay. Now, did you, as far as working with mom, what efforts did you go through to try to prevent a removal?
Well, we did. We actually had a family-based safety services worker. Mom did acknowledge that she had some mental health for herself. So we did get family-based involved. She did get a list of services and resources to reach out to and contact. And then once we got the intake regarding the drug use, both myself and family-based went out to speak with her. And she hadn't reached out to any of the service providers that we gave her on that list, and her drug screen ended up being positive. Once that came back, we brought her to the office. We had a detailed conversation with her. She did have family members that were willing to get the children. However, they were out of town, and I believe it was the Serenity Home in Plainview at the time of trying to work with her. She did not have anyone appropriate to care for her children, so she could go to the treatment facility. They had closed, and she concluded with, confirming that she didn't have anyone to help her and that she felt her only option was to allow CPS to take control of the children while she get herself together.
Okay. So, and just to clarify on that, so after y'all confronted her with the positive drug screens, she stated she did not have any appropriate supervising parties.
Correct.
And that she needed to work on herself.
Correct.
And was not able to do that with the children in her care at the time.
Correct. And she also denied being a user of any drugs. So in order to go to the treatment facility, you have to admit your use.
Okay. But at the end of those conversations, mom decided it was best if CPS take care of her children while she tries to work on herself.
Yes, sir.
And so essentially mom rapid or refused to accept parental responsibility at that time.
Yes, sir.
And that is how the children came into care.
Yes, sir.
And do you believe that was in the best interest of the children?
Yes, sir.
Now you stated you were able to get up with dad afterwards, correct?
Yes, sir.
And he came back to Amarillo after the removal?
Yes, sir.
Was he in a situation at the time to be able to take the child into his care?
No, sir. Miss Galloway was actually helping him out as he had just gotten back, and his support system was in the state of California.
Okay. And the other support system was Miss Galloway?
Yes.
Okay. And he agreed at the time of your conversations to allow the children to stay in the care and the work services?
Yes, sir.
And you believe at that time, those were the best decisions for the children and in the best interest of the children?
Yes, sir.
Or of the child in this case, I'm sorry.
Yes, sir.
I'll pass the witness, Your Honor.
Okay, Mr. Eldridge, any questions?
So, Ms. Galloway basically voluntarily placed this particular child with you guys. Is that correct?
Yes, sir. Her living situation was unstable. Living with her mother, they constantly had bouts. She constantly left the home. The home environment wasn't good for the children either. And mom was just kind of a little all over the place. And like I said earlier, she didn't admit to her drug use and reported that it was due to the environment she was living in with her mother. So we weren't able to get her into the treatment facility, and the family members that were willing, they were not in town, and they weren't going to be in town within 24 hours or so.
Okay. And then this, you don't have anything to do with the service plan and what she did complete and didn't complete later on in the case. Is that right? You're just the primary investigator in the beginning?
Correct.
Okay. So I don't have any further questions, Your Honor.
Okay. Mr. Taylor, any questions?
Just a couple, Your Honor. The concerns that you encountered during your investigation regarding possible prior domestic violence in the home, as I understood your testimony, did not involve Joshua Fletcher, but involved the father of the other child. Is that correct?
Yes, sir.
Okay. And as far as Joshua was concerned, he was an absent parent, or what you would call a non-offending parent?
Yes, sir. He hadn't seen his child since she was 1 year old at that time.
Okay. And he did not return till after removal?
Correct.
But was not in a position to take the children, basically, so he agreed. Is that correct?
Correct. Yes, sir.
Nothing further, Your Honor. Pass the witness.
All right. Ms. Vaughn.
Ms. Watson, you had mentioned that the case started because of some medical issues, and you specifically mentioned a toenail injury. In addition to that one specific injury, had Ariana missed a number of visits for both of her children?
Yes, ma'am. 12 months. They initially only went to the newborn screenings, but they had missed 12-month, 15-month, 18-month appointments. There were a slew of appointments that was missed for both of the children.
Okay. If your affidavit in the removal affidavit talked about 7 missed visits for Audrey and 6 for Pandora, does that sound correct?
Yes, ma'am. It was quite a few.
Okay. And then there was the injury and the missed visit for that. Missed
Yes,
follow-up.
ma'am.
Okay.
The visit for the toenail was actually a visit to the ER.
Okay. Those are all the questions that I have, Your Honor.
All right. Mr. Trout, any further questions?
Nothing further from this witness, Your Honor.
All right. Okay. Anybody else have any other questions for Ms. Watson?
Can I ask one, Your Honor?
Sure.
So, Ms. Watson, on the drugs, you said Ariana failed a drug screen at the very beginning of the case. Do you recall what the drug was that was in her system, and if you know how high the levels were by chance?
It was methamphetamine, and it was 934.
Okay. All right.
And that was on an oral swab drug screen.
Okay. Okay. Nothing further, Your Honor.
Okay. Anybody have any further questions for Ms. Watson?
No, Your Honor.
No, Your Honor.
All right. Anybody have any objection to her being released?
No objection.
No objection.
Okay. Ms. Watson, thank you very much. You're free to go.
Thank you, Judge. Y'all have a good one.
Thank you, Ms. Watson.
Thank you. All right, Mr. Trout, you can call your next witness.
Call Madison Carthel, Your Honor. Are you familiar with that case?
I am the case manager for that case.
Okay. And excuse me, does St. Francis keep records in its cases, regular records in its cases?
Yes.
And are those kept in the ordinary course of business?
Yes.
And are those entries made at or around the time the events occur?
Yes.
Are the entries made by a person with personal knowledge?
Yes, they are.
Do you have access to those records?
I do.
And are you a custodian of records?
Yes.
Have you reviewed, you weren't the original worker on this case, is that correct?
Correct.
You moved into this case when?
Took over this case in June.
Okay. But you have gone back since you've been on the case and reviewed the case files, for the life of this case.
Yes.
Okay. When the case is turned over to St. Francis after adversary hearing, what is your first steps?
We reach out to the families and we set up a family plan of services to go over for the families to complete, depending on reason of removal for them to be able to be reunified.
Okay. And when you say family plans of service, what are those?
They are documents that state specific services that the parents have to complete in order for us to return the children safely.
Okay. And were family plans of service created in this case?
Yes, sir.
And were those filed with the court?
Yes.
And are family plans of service made orders of the court?
Yes.
Was that done in this case?
Yes, it was.
Did you receive the exhibits I sent out?
I did.
Can you look at exhibit number 1 for me, please?
I've got it.
Okay. And can you tell me what exhibit number 1 is?
As a family plan of service?
And is this family plan of service for this case?
Yes.
And is this the family plan for Ariana Galloway?
Yes.
And were these filed with the court?
Yes.
Were they filed on July 24th of 2023?
Yes, they were.
And did mom sign these orders, this family plan? I mean,
She did.
and what date did mom sign the service plans on?
She signed on 7/21,
Okay,
July.
so 3 days before they were filed.
Yes.
Okay. Your Honor, I'd ask to admit exhibit number 1 is the family plan of service that was generated and just testified to in this case, and it's a certified copy of them.
Okay.
I don't have any.
Objection.
No objection.
All right, petitioner's exhibit 1 will be admitted.
Thank you, Your Honor. Ms. Garland, could you look at exhibit number 3? Do you have it in front of you, Ms. Garland?
Yes, I do.
Sorry. Can you tell me what exhibit number 3 is?
It's a status hearing order and notice of next hearing.
Okay. And during these status hearings, is that when service plans are generally made in order of the court?
Yes.
And was that done in this case?
Yes.
What date does it state the status hearing took place on?
July 25th, 2023.
Thank you, ma'am. Your Honor, I'd ask to admit exhibit number 3. It's a file marked copy of the status hearing order from this case that came out of this court.
Any objection?
No objection.
No objection.
All right, petitioner's exhibit 3 will be admitted.
Thank you, Your Honor. So, Ms. Garthel, based upon what you just testified to, the date on which mom signed the service plans, the date which the service plans were filed, and the date of the status hearing order, mom knew about the service plans and had agreed to them prior to them being made in order of the court. Is that correct?
Yes.
Okay. Reviewing the case file that you have and your time working on the case, has mom worked cooperatively with the St. Francis on working services?
She has not.
Okay. Let me get to a page here real quick. Has mom consistently drug screened for you?
No.
When was the last time mom did drug screen for you?
She has never drug screened for me in the life of this case. She drug screened for the previous caseworker. Back in April is the last one that I have, and it was a diluted specimen and a presumed positive urine analysis.
Okay. And did you have you attempted to send mom for drug screens?
Yes.
And how do you normally do that? Is that phone call, text message, email? How do you normally send those?
With most of my clients, I will send a text message early in the morning and tell them that they have until 4 p.m. to go drug screen that day. With her, since communication was really hard. I would also try to call her, leave a voicemail, email, and at one point I even showed up to her house to offer to take her to a drug screen.
Okay. And you stated that since she no-showed in May?
Yes.
And she no-showed in June?
Yes.
Twice in June?
Twice in June, yes.
July?
Yes, was a no-show.
No-showed in August? And then according to your report in 9/1, you attempted to try to send her?
Yes.
Okay. And have you been able to get through phone calls or text to mom since then?
No, after September, she blocked my phone number.
Okay. And just to explain, how do you know she blocked you? What do you mean by that?
When I try to call or text, it just goes immediately. My texts do not go through, and it just goes immediately to voicemail if I try to call.
Okay. Has mom reached out to you to state that she has a new phone number?
No.
So as far as, and have you done any searches to try to find new phone numbers or reached out to any family?
They said she has the same phone number.
I'm sorry, say that again.
They said she has the same phone number.
Okay. And who is they?
Her Josh Fletcher and also some Vanita and Katie, her family members.
Okay. So as far as you know, the number you have is still a good working number. It just, none of your stuff goes through to it.
Correct.
When's the last time you had contact with mom?
When I showed up at her house to try to get her to drug screen in August.
Okay. And how did that meeting go?
She was very angry that I was at her house. She refused to go with me or to drug screen and asked me never to show up on her property again.
Okay. As part of working services and service plans with parents, does St. Francis need to check on the home and see the condition of the home and where parents are living?
Yes.
Have you been able to do that?
No.
Did mom ever do her OSAR?
She did not.
Was she required to?
Yes.
Did she participate in psychosocial?
No.
Did she complete a psychosocial in January of 2024?
I'm not sure. I've never received a psychosocial from her.
Will you look at your report? Do you have your report in front of you?
I do.
Okay.
Yes, it shows that Marissa received one.
Okay. And were there recommendations from that psychosocial?
Yes, there were.
Okay. Was it recommended that as long as she can stay drug-free, that she have regular access to her children?
Yes.
Have you been able to verify whether she has remained drug-free?
No, I have not.
And is that due to no showing drug screens since May?
Yes.
Is mom currently getting visits?
No.
And in order to get visits, we need clean drug screens at this time. Is that correct?
Correct.
And mom has not shown us being cooperative to give us drug screens to show that she's drug-free. Okay. It's recommended that she does counseling. Did mom ever do counseling?
She went to 2 sessions and then she never went back.
Okay. So she started but never completed.
Correct.
Okay. Do you know whether is mom employed?
She stated that she is employed at Dollar General. She sent me 2 pay stubs a couple of months ago, and I'm assuming that she is still there.
Okay. So to the best of your knowledge right now, she was employed as of a couple of months ago, but you're not 100% sure right now.
Correct.
Okay. Do you know, did mom ever do parenting class?
She said that she started those. Again, I never received anything stating that she finished them, and I don't know how many she did or did not do.
Okay. Do you know who she was doing parenting class through?
Hope Choice.
Okay. Have you been able to get in touch with them to see if she did?
I did, and they told me that part of their program is asking parents to keep in contact with their caseworkers and let them know how they're doing in the progress, and then they send them the completed form when they complete it, and they're supposed to send it to us, but that she had not completed it, and I never got anything from her saying that she had.
And so in the file and personally sent to you, you've never seen a completion for a parenting class.
Correct.
We've already discussed an OSAR. It was recommended for her to do an OSAR and follow recommendations, but she never did an OSAR, correct?
Correct.
Okay. Do you know whether she ever followed up with Texas Panhandle Centers to help with mental health?
She did not.
Okay. Was she asked or required to do a domestic violence support group?
Yes.
Did she ever complete that?
No.
Sorry, give me 1 second. How long has it been since mom had visits with the children?
She has not had visits with the children since March.
Okay. And I say children, I mean, in this case, the child in this case.
March.
Okay. And we've been in this case over 6 months, correct?
Yes, sir.
Do you know where mom is living right now?
Last I knew, she was living with her mom.
Okay. And is that the address you went to in August?
Yes.
Okay. And to your knowledge, she's still living with her mother?
Yes.
Okay. Do you believe at this time that mom is in a situation to provide the care necessities for the child?
I do.
And is that based upon your inability to follow up with mom due to her not willing to work with you?
Yes.
Did the department, St. Francis, did you give mom the resources to help try to reunite her with the children, or with the child?
Yes.
And one of the many ways is through service plans and helping provide and set up service providers.
Yes.
And mom has not availed herself of those services. Is that correct?
Yes.
Is the department today asking to terminate the parental rights of the mom, Ariana Galloway, as to the child?
Yes.
And is that based upon failed to work services and constructive abandonment?
Yes, it is.
And do you believe that's in the best interest of the child?
Do.
How is the child doing now?
Audrey is doing great. She just started pre-K and she's loving school and she's thriving. She's doing very well.
Now there were some, I believe, some delays with Audrey. Is she doing well in those and catching up?
Yes, she is.
Okay. Is she placed with family?
Yes.
And is, to your knowledge, is family adoption motivated if that becomes available?
Yes.
Okay. And so based upon your knowledge of the case and the way everything's gone, you believe it's in the best interest of the child?
I do.
Now, as to dad, Joshua Fletcher, did dad execute an affidavit of voluntary relinquishment?
He did.
And did he execute that on the 14th day of September 2024?
Yes, he did.
Have you had the opportunity to review that relinquishment?
I have.
Did the dad, respondent dad, sign the relinquishment?
Yes.
Were there 2 witnesses to that relinquishment?
Yes.
Was it notarized?
Yes.
Has the department consented to being the designated managing conservator of the child?
Yes.
And was this filed with the court on November 6th of 2024?
Yes, it was.
Your Honor, I'd ask to admit exhibit number 2. It's the affidavit of voluntary, certified copy of the affidavit of voluntary relinquishment signed by dad that was just testified to.
No objection.
No objection.
All right, petitioner's exhibit 2 will be admitted.
Thank you, Your Honor. Mr. Arthur, is St. Francis today asking to terminate the parental rights of Joshua Fletcher based solely upon his affidavit of voluntary relinquishment?
Yes.
And do you believe that's in the best interest of the child?
Yes.
And do you believe it's best interest to allow or to ask the court to terminate the parental rights of both parents so that the child may be adopted by family and stay with family?
Yes, I do.
And that's in the child's best interest. I'll pass the witness, Your Honor.
Okay. All right, Mr. Eldridge.
Your Honor, can I have 1 second? Can we take about a 3-minute recess? I have my client on the phone.
Yes, sir.
Okay, I'm sorry. They came and got me, so I was trying to talk and listen and do all this, but I'm talking to her right now.
That's fine.
Okay. Just give me a couple of minutes, please.
Yeah, that's fine. We'll just take a quick break and just let us know when you're back.
Okay, yes, ma'am.
Your Honor, I'm gonna run down the hall real quick.
Okay.
I don't know if you guys can hear me, but Your Honor, I'm back.
Okay, I think everybody else was taking a quick break, so we'll just wait till we get everybody back.
Yes, ma'am.
Okay. All right, Mr. Eldridge, anything we need to discuss?
So my client, we sent her, when I logged on this morning at 11, a little after 11:30, I had my secretary call and send emails. She got the email. We sent her a link for the hearing. She called back just a second ago and, she hung up. So, that's about all I know. So she said she didn't know about the hearing. I said, well, I sent you a letter back in August and all that. So, I guess she does not. She says it's not worth it. She's got an appointment with her other child and she didn't have time to do this. So I take it she's not going to participate.
Okay, but she had the link and
She has the link and she knows we're in the middle of the hearing and I told her she needed to log on. My secretary told her she needed to log on. This was an hour ago or about 55 minutes ago. So yeah, she's got everything and she could participate.
all right, so you're telling me that 55 minutes ago, your secretary talked to her and she had the link?
My secretary sent her the link and sent her. I get the same. I go straight to voicemail when I call, like Miss Carthel. I don't think I'm blocked, but I go straight to voicemail. So we usually get a response from emails, and so we emailed her, and she did respond by calling. And yes, we sent the link about 55 minutes ago.
Okay, Ms. Goodman, I want to make sure, did you get that on the record? Okay. All right, sir, I appreciate it.
Yes, ma'am.
Okay, let's see.
I think it's my turn to cross-examine.
Yeah, I'd pass witness, Your Honor.
Pass witness. Okay, so Mr. Eldridge, any questions?
Just a few, Your Honor. Ms. Carthel, can you hear me okay? Am I speaking loud enough? Sometimes I don't.
Yes, sir.
So I apologize for that. So I spoke to Miss Galloway a week or so ago, and then she kind of reiterated just a few minutes ago. She has another child, is that correct?
Yes.
And she's had a child since these two kids were removed. I know we've already terminated on the Bennett case, but on the Fletcher case, since both those cases, she's had another baby, right?
Yes.
And are you in, I think she's having to do services for that baby as well, is that right?
It is not a part of my case as of yet. It is under investigation with CPI.
Okay. And what she's telling me is that she's done several drug screens in that case, and that she thinks you guys are from the same agency and should know that she's taken drug screens and passed those drug screens. Is that true or not true?
That is not true. I have not received any drug screens for her current open investigation.
She's saying the last drug screen she took was October the 5th of 2024 and she passed it. So, you know if that's true or not true?
I have no record of that.
Okay. I mean, you guys communicate, I assume, if somebody's talking to her about another child and you're working as a current case, I assume you guys communicate. Is that right?
When this case first opened, investigations did reach out to me, yes.
Okay. I guess my question is, so you're saying you don't have any information, but you're not saying that that's not true, that she hasn't taken and passed these drug screens. You don't really know. Is that what you're saying?
Correct.
Okay. The other child has not been removed. Is that correct?
Correct.
Okay. She's saying that she did complete the parenting classes. Do you know whether that's true or not?
As far as I know, she has not completed the parenting classes.
Okay. And she confirms with everything else that you said is true, but what she did tell me is those two things. She's taken drug screens and passed them, and she did finish the parenting classes according to her. But you don't have that information, right? Did she give reasons? I talked to her a couple weeks ago. When you showed up at her house, I know she was upset. Did she give you a reason why she didn't want to go drug screen right then?
She told me that she had work later that day. I showed up at about 8:30 a.m. I asked her what time she had to go into work. She stated, I believe it was 1 p.m. I said that I would have her back in plenty of time to do that. She told me she did not have time and to get off her property.
Okay. And was she ever given alternate dates and all right, well, if you can't go today, go tomorrow or anything like that?
They normally have to go the day that we send them, but I sent her every other month as well, and she never went for any of those either.
Okay. And you sent those by email, I assume?
Email, text, called. Yes, sir.
Okay. So you believe she got the information, she just didn't show up?
Yes, sir.
Okay. I guess that's all I have, Your Honor. I'll pass the witness.
All right. Anybody, oh, excuse me, Mr. Taylor, any questions for Ms. Carfield?
No questions, Your Honor.
All right, Ms. Zavala?
Ms. Carfield, visits with the children stopped in March. And then you testified that mom didn't drug screen for you starting May forward?
Yes, ma'am.
In order for visits to start back up, did mom need to show one clean UA?
She needed to show at least one clean UA. We could have started virtual visits, yes. And then after a couple, we could have done in person again. We just wanted to make sure that there was no transfer of touch contact and drugs.
So she didn't respond to your request to drug screen. If she did drug screen recently and was negative, did she call you to say, hey, can I start my visits?
We did not.
Audrey's or Hazel is doing really well in her family placement. Is that correct?
Yes.
Okay. And she was pretty far behind at the beginning and had to do physical therapy, occupational therapy. In fact, at least for a while was having 5 different sessions a week.
Yes, she was.
Okay. And her placement has kept up with all of her medical needs.
They have gone above and beyond on all medical needs, yes.
And Audrey was premature, which is part of the problem in wanting to have her monitored regularly when she was young, correct?
Yes.
Okay. And then when she came into care, she was pretty delayed.
She was, yes.
Okay. Would you agree with me that all of the therapy and placements efforts have really paid off and she has really caught up?
Absolutely.
Okay. I pass the witness.
Was Ms. Carthel Audrey, I know she goes by Hazel, but was she the child that initially there was some concern was autistic?
Sure about that, Judge.
Okay. All right. I know you weren't the investigator. Has there been any diagnosis of autism with her?
No, not to my knowledge.
Okay. All right. Mr. Trout, back to you. Any further questions?
No further questions, Your Honor.
Okay. And Mr. Eldridge, is it all anything further with this witness?
No, Your Honor, not for me.
Nothing further, Your Honor.
Nothing further.
All right then, Mr. Trout, any further witnesses or does the department rest?
Department rest, Your Honor.
Okay. Mr. Eldridge, anything to present today?
No, Your Honor, I don't have a client, so.
Okay, do you rest?
Yes, ma'am. I rest, close.
And just for the record, I have checked again. She is not in the waiting room.
Yes, ma'am.
All right, Mr. Taylor.
Also rest, Your Honor. No witnesses, nothing to offer.
Okay. All right, Ms. Zavala.
No witnesses. I rest and close.
All right, Ms. Zavala, do you have a recommendation to make?
Yes, Your Honor. I do believe it's in Audrey's best interest that parental rights be terminated at this time, both for mother and father.
All right. I know that at the beginning of this hearing, I said I was going to reserve ruling, but since we have had contact with the mother since then, and we started this hearing, right around 11:30, I think a few minutes after that. And Mr. Eldridge just told us that Mom was given the link. It's now 12:39. Mom was given the link probably about an hour ago now. So she was given the link and the opportunity to log in and participate virtually at the same time that we started this hearing. She could have participated from almost the very beginning of this today. If my time frame is correct. Anybody? Am I way off base with that?
No, I don't believe so, Your Honor.
I agree, Your Honor.
I agree, Your Honor.
All right. So in spite of what I'd said earlier, that changes things significantly. So I am going to go ahead and render today. At this time, I do find by clear and convincing evidence that it is in the best interest of the child to terminate the parental rights between the child and her father, Joshua Fletcher, based on his voluntary relinquishment of parental rights under Texas Family Code 161.001B1, the K grounds, and best interest of the child under 161.001B2. I find by clear and convincing evidence it is in the best interest of the child to terminate the parental rights between the child and her mother, Ariana Galloway, based on Texas Family Code Section 161.001B1, the N and the O grounds, and the best interest of the child under 161.001B2. At this time, I will name the department as permanent managing conservator of the child. I'm going to continue her current placement. I will dismiss all court-appointed attorneys after the de novo and appellate timeframes expire, with the exception of Ms. Zavala, who will remain as the child's attorney and guardian ad litem. Counsel, as always, be mindful that your de novo timeframe does begin to run since we've rendered an open court. And also, if you're instructed to file an appeal, please do not do so until a final order has been signed and adopted by the referring court. All right, I appreciate everybody today. Thank you very much. The court will be in recess until we start our next case at 1:30. I will leave the feed up and see some of you back at that time. Oh, and for those still involved in this hearing, I'm sorry, our first review will be February 13th of 2025, and that'll be on a 9 o'clock docket.
Thank you, Your Honor.
Okay, thank you.
Thank you, Madison.
Thank you, Judge.
We are here today on our final. We're conducting this through Zoom. We are live streaming, and Ms. Goodman is making our record today. Okay, we'll go ahead and take announcements.
Daniel Child for the Texas Department of Family and Protective Services. We're present, ready, Your Honor.
Excuse me, Jay Michelson on behalf of Juan Rivera III, the father. He is not present, and I have had no contact with him.
Stacy Zavala on behalf of Waqin.
Okay, and Sarah Rivera, I do not see present. Let me just ask, was she made aware of the final hearing because she doesn't have an attorney since she's a non-parent? So did anybody send her notice of the final hearing?
Yes, Judge, I talked to her on my monthly visit this month.
Okay, very good. And was she given the link for today?
She does not have the ability to do an electronic link.
Well, okay. Did she want to participate?
I discussed with her what was going to be happening today and gave her the option of transporting her to a place where we could sit down and do the link together. And she said she didn't want to do that.
Okay. All right. Just want to make sure that the opportunity was given to her.
Yes, ma'am.
All right. All right, then. Y'all have any announcements to make, or are we ready to start taking testimony? Excuse me.
I think we'll take testimony, Your Honor. Mr. Michelson's, I don't believe has had any contact with his client on this, and been no contact throughout the case. We're not seeking termination on anything. It'll just be prove up on PMC case.
Okay. All right, then. Who's your first witness?
Tim Cole, Your Honor. And how are you familiar with that case?
I am the primary caseworker or permanency specialist and have been since the case began.
And just to start out with the child, how is the child doing?
Waqin is doing pretty well. He is placed at an RTC in Rosenberg, where he has been since August. He did recently have a suspension for a fight at school, so they have moved him to the alternative program at a different location where you have to wear a uniform and class sizes are smaller. And he has to spend 45 days, possibly less, at the alternative school. But that's not normal for him. And I don't know the circumstances of the fight yet. It was just like late last week that it occurred. But other than that, he's been doing well.
Okay. And that was going to be my next question. Has he had an instance like this previously, or is this kind of out of the norm for him?
It is out of the norm.
Okay. And he's in a situation where he can't go home to grandmother. Is that correct?
That's correct.
Okay. And dad, have you had any contact with dad?
I have not. I have tried on a monthly basis through whatever means we have at our disposal. I've asked grandmother if she knows where he is. She does not know where he is. We did a diligent search back in June, and that did not produce any leads as to where he is.
Okay. As far as you have grandmother and you have dad, do we know of any other family members that could possibly take Waqin?
No, I do not.
Okay. Grandmother hasn't given you any other names?
No.
Okay. Are you here today asking, is the department asking for permanent managing conservatorship to be awarded to the department and for grandmother and dad to be named as possessory conservators?
Yes.
And again, is that due to Waqin not having anywhere to go, any family to go to, and cannot return to grandmother's at this time?
Yes, that's the reason.
And dad, according to grandma, I believe dad is homeless or from friend to friend.
She describes him as on the streets.
Okay. And so he would not be an appropriate, to your knowledge, would not be an appropriate placement for the child.
Without any knowledge to the contrary, I have to assume he would not be.
Okay. And do you believe that Waqin he's in a good placement now? I know he's had an issue last week, but he's in a good placement now.
Yes, he's in a good RTC. I have another youth that's there as well, and I feel like it's a very good RTC. It's been taking care of the needs of both of my youth there.
Has he stated what he would like to go forward, or is he good where he is? How does he feel about his placement?
Waqin enjoys his placement. He's a rule follower, and he feels safe in his placement, and being given structure. So he's where he would like to be.
Do you believe it's in the best interest of the child for the court to award PMC to the department?
I do.
And for parents to have possessory?
Yes.
And grandmother to have possessory?
Yes.
Is the child and grandmother, are they still having visits?
Not in person, just due to her income situation and the fact that she's raising quite a few kids there at her house. But they do talk 1 to 2 times a week, and they have family therapy once a month.
Okay. And does that all seem to be going well?
It does. Yes.
Does he seem to enjoy that?
He does. He does. He's bonded with his grandma.
Are you asking for that to continue the visitations with grandmother on the phone?
Yes.
Does he have any contact with dad that you know of?
No contact at all.
Okay. There's prior orders for dad pay child support and medical support. Are you asking that those stay in place?
Yes.
And you believe that's in the best interest?
Yes.
I'll pass the witness, Your Honor.
Mr. Koval, just a clarification. He didn't, I understand maybe he had a change in school situation because of this incident, but he didn't have to change placements, did he?
No, ma'am. He did not have to change placements. It's just the alternative learning program or whatever they call it in that school district.
Like we call it AEP or DAEP, or just
Yes.
because he had that, he was involved in that somehow.
Yes, ma'am.
Okay. All right. I just want to make sure I understood that correctly. Thank you. All right. Ms. Michelson, do you have any questions?
No questions, Your Honor.
Okay. And Ms. Zavala?
Mr. Koval, Waqin has known since the beginning of our case that he could not go back to live with grandmother, correct?
That's correct.
Okay, so nothing that's happening here today would be a surprise to him in any way.
That's correct.
I pass witness.
And have you started having conversations with him about independent living and what he wants to do in the future and those kinds of things?
Yes, ma'am, we have, and he has completed his PALS classes, and we will continue working on getting his personal documents together and working toward that future.
All right, and since he is 16, where do we stand with driver's license for him?
That's something that we need to do. I know that we are in the process of getting his birth certificate. And once we receive that, then we'll be able to request his social security card, and then we'd be able to get his state ID. And if he wishes to go for his driver's license or to attend the driving school to get his license, placement will be able to help us with that. But the birth certificate has been requested. We're just waiting to receive it.
Is it a Texas birth or?
It was a Texas birth,
Okay.
and it's supposed to be coming from Austin. I asked about it last week of my supervisor, and she said that she had asked about it a while back, but just taking a little bit to get it.
Okay. Well, it's just my new thing at age 16. I'm going to start beating the bushes about where we stand on all of this, because it just seems like we blink and then these kids are ready to age out. I don't know, those
Yes,
last
ma'am.
2 years go fast. So I think I read that he would like to go to college. Is that correct?
Yes, he has said that.
Okay. All right. Is he a pretty good student?
He was a good student at Pegasus when he was there. Of course, that was a different kind of environment with the online school, or on campus school, I should say. He started off well at Randall High School, where he is now. And then the grades started to drop right before this fight. So I'm working with the placement to have him explore with his counselors that he sees there to try to determine what's going on, because the drop in grades has just been very, very recent, and then this fight has been very recent. We want to get to the bottom of what's going on.
Okay. We are live streaming. I'm going to pose a question in the chat feature. Y'all bear with me real quick. This will go to everybody. I'm going to throw out there, doesn't really bear on this final hearing, but for our next review hearing, I just am posing that question.
Not to my knowledge, Judge.
Yeah. Okay.
And Judge, I just thought about this. We're in a modification that involves multiple children that were in the original case that we filed, that we intervened into. Since we are asked for child support and medical support to the department from dad, and to keep that orders active, I believe there were 4 children in the original case. Looks like one has already turned 18. One will be 18 in January, I think. And then there's a younger sibling. It'd be easier for us to sever this one out, since we'll have a new final order as to Waqin.
Okay.
I think would be the easiest route we'll do, and that is do a severance and then a final order with the new conservatorships and child support stuff in there.
I would agree. Is he under a support order already, though? He is? Okay.
Yes, ma'am. There was one in the last order was in 2019 that involved all 4 children in child support to grandmother. So I think she should still be receiving until January. We're supposed to be receiving child support from dad on the one that should age out in January. We originally routed our child support on Waqin to the department in the original order, or the adversary order, temporary order. And then there's a younger sibling that grandma should still be getting child support in. It's, from what I can tell, that's the still active orders.
Okay. So for purposes of what we're doing today, do you want, or how do you want to handle it? Do you want to I mean, we're not terminating. Do you want to deal with that after it's severed? Is that what you're saying?
Yes, ma'am. I think in order to get the child support to where it's not too mixed up on everybody, get him severed into his own case since we're putting in new orders. Because in the prior orders, grandma and dad had joint managing conservatorship, so we're changing them from joint managing to possessory, only as to this child. So I think it'd be better to sever him out and put in the new final orders as to him.
I'm just thinking procedurally, all right, if we do that, then if we don't say anything about child support right now, or do you want to just say it will, his support will be continue to be redirected to the department right now? Then,
yes, ma'am.
Then if we don't do that and we address it later, then don't we have to go back and reserve dad? If we're silent about it today.
Yeah, I think we would be if we were silent about it today. I think we'd have to, that'd be a
modification.
It'd be a modification at that point.
So do we want to just, and maybe I'm misunderstanding you. I thought you were wanting to just do nothing about support today, wait till we get the final order entered, get him severed, and then address child support. I may have misunderstood you.
Well, I'd rather not do that way. I'd rather get it severed out and then do a final order in the new case number. It just occurred to me that we probably need to do that.
So you want to just finish taking your testimony today, and then we just file your motion for severance, and then wait, and then I'll sign the final order when you get that done?
Yes, ma'am. I think that would be the best route. If we can do that.
You see any problem with the fact we've called this hearing under this cause number?
Probably.
Not trying to throw a monkey wrench out there.
No, I threw the monkey wrench because I didn't see this earlier.
What about an oral motion to sever?
I'm good with an oral motion to sever. I don't know what the new case number would be under the clerks.
No, but I think we can just say, if you do an oral motion to sever, I can grant that severance, and then, we'll finish taking testimony, and then we'll get the new cause number, and then the final order can go in under the new cause number. I like that better.
I do too. I would make an oral motion to sever Waqin out into his own cause number.
I would second that motion.
Okay, any objection to that?
No objection.
All right. So I'll grant the department's oral motion to sever Waqin out of cause number 9. His case will be placed under a new cause number, and our final order will be entered under that cause number. So with respect to the final order, then, how do you want to handle the child support issue?
Well,
Dad pays based on minimum wage for the one child, with the calculation of one that's still under 18.
I'm good with that, Your Honor. Like I said, this prior order has the step downs in it. After January, it will be. But yeah, I think that'd probably be the easiest way to recalculate it based on that.
And if it would prevent any confusion, if the step downs in January, we could make the new child support effective February 1st. Minimum wage, one child in care, one in another order.
I have no problem with that.
Okay, so in our order, we're going to say father to pay child support based on minimum wage for one child in this case, and one child in another case.
Yes, ma'am.
In that prior case. Okay. he ordered to pay medical support in that order too?
Yes, ma'am. Let's see. He was ordered to pay $101 a month in addition to the child support he was paying. Of course, at the time that involved all 4 children.
Mm-hmm.
Um,
Why don't we, let's just, the standard now would be $50 a month for the one child. So I think we just say father to pay $50 a month medical support.
yes, ma'am.
Are you good with that, Mr. Michelson?
Yes, Your Honor.
Okay, as good as you can be with that client here, I understand. But that's just the guideline, so, okay. All right, and then I kind of have interrupted you, so you may have some more testimony you want to put on about visitation and whatever else, so I could just see kind of a quagmire.
Yeah, no, I did. Sorry, I brought that up in the middle of this.
No, it's fine.
One thing, Your Honor, is just to take judicial notice that we did. We're not able to personally serve Dad, but we did publish on Dad, and that publication took place on August 16th of 2024.
Okay.
And Grandma was personally served with the case.
Correct. All right. Okay, since there's been no contact between the father and this child in quite some time, what is the department requesting as far as visitation?
I'd request that visitations with grandmother continue as they are. Visitations with Dad, at this time, be no contact with Dad.
Do we even know the last time you had any contact with him?
I know, Mr. Cole, do you know when the last time?
I can't give a specific answer. I know that it's been more than a year and could be quite a bit more than a year.
He hasn't had contact with him since we've had him in care, correct?
That's correct.
Okay, that's been almost a year. So, okay. All right. Anything further from Mr. Koval?
Nothing further, Your Honor.
All right. Mr. Michelson or Ms. Zavala, do either of you have any further questions for Mr. Koval?
No, Your Honor.
No questions.
All right, then you have an additional witness.
No additional witnesses, Your Honor.
All right, then. Based on the testimony and what the department has requested, I do find it would be in the best interest of Waqin. First of all, I've granted the oral motion to sever, and Waqin will be placed in a new case under a new cause number. Under that new number, the Department of Family and Protective Services will be named the permanent managing conservator of Waqin. Mr. Rivera III will be ordered to pay child support based on minimum wage for one child in this case, and having another child in the prior case. That would, let's just make child support effective beginning February 1st.
Mm-hmm.
And medical support in the amount of $50 a month. Right, that'd be February 1st of 2025. Based on the fact that the child has had no contact with the father in a substantial amount of time, and we know very little about father's living situation or lifestyle, I'm not going to order any specific visitation at this time, and just say that there would be no contact until further order of the court or agreement of the parties. I'll dismiss Mr. Michelson from the case. Oh, I forgot to say, father and Ms. Rivera will be named as possessory conservators of the child. My apologies. Okay. Mr. Michelson will be dismissed from his representation. Ms. Zavala will remain in the case as the child's attorney and guardian ad litem. Okay. All right, I appreciate it. I think that's it. As soon as we get that new number, we can get it entered, but
Yes, ma'am.
just let me know.
Will do.
Okay. Thank y'all.
Thank you.
Thank you.
Thank you, Tim.
Shame on you for making me have to think about things.
Well, I made myself have to think on that one. I looked at it, last week and I said, we got this and this, and then it just all of a sudden it hit me. I'm like, well, I think I need to do this now.
Yeah.
I don't know why that took so long to hit me.
It's just the way it is. All right.